Justice Granny Noonan presiding.
Good evening, dearies. How are we doing?
Doing fair, Your Honor.
I am old, dear. Speak loud.
Doing fair, Your Honor, and I understand.
Doing well, Your Honor.
Okay, dear. We are here to hear the appeal of Mr. Richard Anderson versus the state of San Andreas. Each side will have 15 minutes. And you may go longer if I ask you questions. There will be no arguments between the parties. Okay, dear?
Understandable,
Yes,
Your Honor.
Perfect, dear. Now, appellant, let us get this underway, dear.
All right, thank you, Your Honor. Good afternoon. Of course, may it please record. My name is Oliver Hall. Beside me is Cyrus Hunter. We, of course, are representing the appellant in this case. Now, first and foremost, the appellants would wish to reserve 5 minutes at the end for rebuttal. That's, of course, possible.
No, dear.
All right, Your Honor. Now, in this case, we are dealing with a multitude of issues that occurred in the trial court. Now, the main error on the part of the trial court was that the trial court, essentially, they openly dismissed a case without a pending motion to actually drop charges. Now, as was specifically cited on the original docket, specifically stated by the state that they were dropping charges, quote unquote, for now. That wasn't an actual formal motion that was presented to the court. And essentially by the trial court, accepting this quote unquote request that a formal motion actually being submitted, essentially made a decision on its own without a pending motion to do so. Now, overall, this was highly prejudicial towards the actual appellant in this case, the defense at the time. And overall, the trial court essentially making a decision on its own without any sort of request from either party overall is highly prejudicial in any sort of circumstance to any party, whether it be in a criminal court, civil court. Overall, a court and a judge making a decision without any sort of pending actual motion is prejudicial to the other side. Now, more specifically, the trial court, of course, ruled on a quote-unquote motion in the incorrect order. If this court does agree that it was a motion, then the trial court did in fact rule in the incorrect sequence in which they were submitted. Of course, as is most fair to both parties, the trial court should either, one, rule on motions as they are submitted in chronological order, or collectively at the exact same time. Neither of that was actually present in this case. The trial court immediately accepted a motion, you could say, by the state without ever, it seems, actually considering or ruling on the motions that were originally pending by the defense. Overall, when it comes to ruling on motions, a trial court, it simply must go in the order that they are submitted. That's how it is most fair to both parties. And essentially, other errors that did occur were in the actual ruling of the orders. A formal ruling wasn't ever given as to the pending motions. Now, of course, we would assert that those motions, they do need clarification from this court, more specifically as to how the Speedy Trial Act of 2021 actually applies. It was, of course, unclear how the actual statute is written, and it was a motion was pending as far as a trial court to rule on how that statute actually should be interpreted in that case. And of course, the appellant would assert that as far as the submission of any sort of indictment, the indictment must be filed within 5 days, 23 hours, and 59 minutes and 59 seconds of the actual date of arrest. Anything more is, of course, further than 6 days, which, of course, is statutorily required and is a violation of the defendant's rights. With that, issue that wasn't actually addressed, we believe it should be addressed in the appellate court here today. Further is the issue of the motion that was submitted as far as the motion to request a separation of trials. Now, in any sort of case, when you're dealing with a defendant that is alleged to have broken the law on a multitude of different occasions, overall it can become far too confusing for any court to hear charges that are, of course, taking places on multiple different days. That's exactly what sort of happened in this original trial. The defendant was charged with incidents that took place, I think it was a week or more ago, charged also at the same time with charges alleged to have happened more recently on completely different days regarding completely different incidences. Those two motions in general should be actually addressed by this court. Further, the indictment in specific was filed incorrectly. We'd also assert that overall the trial court should not have heard this trial at all because the indictment was filed incorrectly. The indictment specifically did not specify a victim as to what the defendant was being charged as to have harmed. These, of course, would be the conspiracy to commit murder charges. So, of course, with all that in mind, it's quite clear to see how the trial court made a multitude of different errors in this case. Overall, the appellants would ask for, one, the reversing in full of the ruling by the trial court. We, of course, further request whether or not, I'm sorry, let me back up a moment. There is actually another issue at play in this case, which is whether or not the state can file charges, then drop charges, and then a single day later file those exact same charges again. In effect, again, violating a defendant's rights. If extending the point in which the Speedy Trial Act can actually encompass sort of case, it is a violation of a defendant's rights for overall a defendant to be arrested possibly 6 days at the most, have the indictment filed, dropped, and then a couple of days later for the indictment to, exact same indictment rather, resurface and be filed again. So that's another core issue that should be addressed by this court. Now, overall, there does need to be clarification as to the motions, as to the specifics that go into the Speedy Trial Act, as to whether, of course, the state can file, then drop, and then refile charges. And, of course, the appellants would request the dismissal with prejudice of the indictment and all future indictments in full. As to the numerous errors that were conducted in the trial court, and then, of course, it did reappear at a later date there. I believe Mr. Hunt may have more to add. I believe that's the main arguments from the appellants at this time. Right? Do you have anything to say?
No, I'll just take the question.
Is that all you have, dear?
Yes, sir.
Okay. Mr. Blackstone, is it?
Yes, Your Honor.
Go ahead, Counselor.
Your Honor, to simply put, the two appellants before you had brought it upon themselves to to go forward as to ask to be counselors. As far as what all the motions that the defense had said, never once did the Honorable Morales acknowledge Mr. Hunt nor Mr. Hall as counselors. Regardless of the situation, the judge has the right to make that final decision as to accept those, as by the state of San Andreas versus Stephen Garrett case of the, again, appointment of one of the appellants here in this courtroom, when Mr. Hunt tried to appoint himself at the behest of Mr. Garrett, The Chief Justice ruled and stated that in good conscience he cannot allow this.
Counselor, I will remind you, dear, this is not a bar hearing. This is for the
Yes.
appeal. Are you aware,
Right.
dear?
Yes, Your Honor. No, I'm bringing that up as more or less the reason for. I'm trying to make a point. I don't mean to make it towards that complaint. What I'm trying to say is that they acted ahead of. They basically, in a sense, jumped the gun by asking to be counsel. The judge never acknowledged them as counselors, and in that case, by that they revealed their hand by submitting motions before the judge had approved them. So basically, every motion they put forward was put in vain. And because of that, Your Honor, also, as the reference for what the appellants are trying to say is that I didn't ask for the case to be dropped with or without prejudice, keep note of the state of San Andreas versus the Elisha Wessler, when the former district attorney, Chance Noonan, asked for the state to drop all charges, despite he did say de mortuis nihil nisi bonum, basically in remembrance of the now, apparently. I guess that means he's gone. So, Your Honor, just be in that case there alone, with the Chief Justice making that rule, accepting that ruling,
Sir?
that is why I said I didn't ask for it to be dropped with or without prejudice. I simply asked for the charges to be dropped. Now, however, I do understand the situation with the appellants seeking additional answers regarding the reason for this, but again, as far as we're aware, the court never acknowledged them both as counsel. And need I remind, they're also just public defenders.
Dear, stick to the facts of the appeal, please.
Yes, Your Honor. It is just simply that the judge never acknowledged them as council members, and all their motions were put in vain. And as for this state of San Andreas versus Elisha Wessler, I had all rights to just say dropping all charges.
So, dear, let's assume for a moment that they were appointed officially counselors by the judge. Okay, dear, let us assume. Then what?
Then we would have to wait for the Honorable Morales to make his decision.
But the Honorable Morales did make a decision, dear. Or didn't
Yes,
he? Which one
he
did he
did.
do?
He did make a decision.
He
He
did?
chose,
Oh, yeah.
yes,
There's like 6
upon
more,
me
7 more
motioning to
people.
drop all charges, he acknowledged it and dismissed the case with
You
prejudice.
motioned to drop the charges, dear?
Well, have
Yes,
you tried
Your Honor.
walking around and nothing's
You
changed?
motioned for it, dear.
Well, I said the state
Yeah.
wishes to drop all charges,
Okay, dear.
as also referenced in the state of San Andreas versus Elisha Wessler.
Yes,
the
dear,
former-
I understand. Words
10
mean
other
things in the
people besides
courtroom,
those
dear.
2.
Yes, Your
Emotion
Honor.
is emotion.
So yeah, I'd probably
A declaration is a
open up your eyes for a
declaration.
minute.
Do you understand?
Yes, Your Honor.
Okay, thank you, dear. Continue.
Oh, that was everything, Your Honor.
That was everything, dear?
Just based on those 2 factors, Your Honor. Because this is all, well, unless we're moving into the, hold on 1 second here.
No, dear. Okay, dear. We shall return in 10 minutes.
Thank you, Your Honor.
Thank you, dear.
All rise. The Superior Court of the State of San Andreas is back in session. The Honorable Justice Noonan still presiding.
Hello, dearie. You have been all good in this courtroom today, so after it's over, everyone gets a cookie. Woo! Mac will hand them out. Thank you, dear. Okay,
Yes,
dear.
sir.
I am going to affirm the lower court's decision. And the way they acted There was no trial. The DA dropped charges before anything happened. A motion was not looked at. That happened. That is unfortunate for you, dear. But the way it is, dear, is they drop charges. We see no reason to continue on or to rule on a motion. Because dropping charges is not, no matter what the DA says here, dear, is not a motion. Okay? We are not going to comment on any violation of the Speedy Trial Act in regard to this particular case. And the lower court's decision is affirmed. Court is adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.